Back to the Adams and Reese HR Summit. My name is Greg Rouchell. I am the Labor and Employment Team Leader here at the firm. I'm joined here by my colleagues, Craig Wilcox out of our Houston office and Lauren Tafaro out of our New Orleans office. I am out of our New Orleans office also. We are going to be talking today about non-compete agreements. It's not one size fits all. Hopefully you'll know what we mean by that by the end of the presentation. There's just a little bit of housekeeping that we need to do before we get started. We'd love to hear from you today. If you have any questions during the presentation, please type them into the question box, and it's on your control panel. Only the presenters, the three of us, can see the questions, and if we have time at the end, we're going to go ahead and address those questions for the group. Also, near the end of the program, this is very important, you'll see a badge on your screen, and you can download your continuing education certificates at that time. So with that, I think I'm going to turn it over to you, Lauren.
Sure. Before we get started, we wanted to talk about some of the terms that we'll be using throughout the presentation so that you have an understanding as to what they mean. Restrictive covenants. These are provisions in a contract with an employee that prevents him or her from doing certain things after the employment relationship is severed. One type of restrictive covenant is a non-compete agreement, and that prohibits an employee from engaging in certain business after he or she leaves the employer. That would be in competition with the former employer. Another type of restrictive covenant is a non-solicitation agreement. And this is a provision in the contract that prevents the employee from stealing or taking other employees or customers when that employee leaves the former employer to go work at a new employer. Lastly, we're going to talk about confidentiality agreements, which is also a contract with the employee that prohibits the employee from using or disclosing confidential information of the employer. Within that agreement, the definition of confidential information is very specific, and it outlines the type of information that the employee cannot use when he or she leaves employment. That's also outline what the company trade secrets are that are also, the employee cannot use that as well. So with that, we're going to start our panel discussion. And the first question, Craig, I'm going to pose to you. There may be some attendees that are wondering why this applies to them and does the law not already protect it. Can you explain why this is important?
Sure. Thanks, Lauren. So the law does provide some protections already for both the employer and the employee when the employee is about to leave their employment. For example, for the employee is free to plan and prepare to leave their employment, and they can even take active steps in preparation of leaving their employment, and there's nothing unlawful about that. The employee can also use the general knowledge, skill, and experience they gain during their employment after they leave without violating any laws. However, the law does have protections for the employer in that the employee cannot misappropriate, disclose, or use their former employer's trade secrets. And so, why does a non-compete help beyond what's already provided for under the law? I think it can provide several additional protections beyond what's already provided for. First, in order to enforce a well-written non-compete agreement, the employer doesn't have to prove that the employee misappropriated or stole trade secrets. That may not have even happened. Or it may be difficult to prove, even if it did happen with a sneaky employee. So it doesn't require enforcing a non-compete agreement proving that the employee stole something. Second, I think that a non-compete agreement can provide more certainty and clarity for both the employer and the employee about what's off limits when the employee leaves. With a specific contract addressing things like what activities are prohibited after the employee leaves, where can the employee compete and not compete being defined specifically, and how long are those restrictions in place. That provides, hopefully, more certainty to both the employer and the employee about what's okay after the employee leaves. And then finally, what I think a non-compete agreement can do more effectively than what's already provided for under the law is that a non-compete agreement can be very effective in protecting customer relationships, business goodwill, investments in specialized training of employees, and it can be particularly helpful when we're dealing with high-earning employees that generate a lot of business for the company and protecting that business after the employee leaves.
Greg, the next question is for you. For clients that have multi-jurisdictional presence, meaning they have offices in multiple states, can they just use one agreement across all states?
No, that doesn't really work, Lauren. And the reason is that typically that non-compete agreements, it's going to be a matter of state-specific law. And so there's several nuances, and we're going to talk about those in a minute, between the various states' laws. And so what might be okay in state A is not going to be okay in state B. And so it really can cause problems for the employer if they try to make a one-size-fits-all and they try to do a uniform agreement and use it throughout the country. That might work for some states, but in many cases, it's not going to carry the day, and you're going to have an issue where you're trying to enforce a non-compete and it's invalid under applicable state law. We're going to get into that in a minute too. There's some legal pitfalls there with respect to that issue. It's one of those things where you have to assess for each of your employees, where is the employee living and where is the employee residing. Most judges are going to apply, generally speaking, we're going to get into this more in a minute, most judges are going to apply the law of the state where the employee lives and works. And there's going to be some other factors that might go into that analysis, but generally speaking, that's what state's law is going to apply. So again, it's really important that you assess whether or not the agreements that you have in place are in fact compliant with those laws where the employee lives and works. And we're going to get into that a little bit later as well. Finally, I want to address something that happened recently. On July 9th, President Biden issued an executive order banning non-compete agreements. And I got a flurry of emails and calls from clients simply asking, wait a second, did the president just invalidate my non-compete agreements? The answer is no, not yet. What the president's executive order says upon closer examination is he is encouraging the Federal Trade Commission to come up with a rule, not legislation, a rule that would prohibit non-compete agreements and other various aspects of the restrictive covenants that we're going to be talking about today. One of the things that he is known for is that he is very pro-labor, he's very pro-employee, and he is going to make antitrust violations a focus of his administration. And so this is just the next step in trying to achieve those goals by trying to get the Federal Trade Commission to implement some rules and regulations regarding non-compete agreements. Now, what would that mean if and when they finally act? Well, you can almost be guaranteed that somebody is going to raise a constitutional challenge to the FTC's ability to implement rules. Boiled down to its simplest terms, government agencies can only write rules that interpret existing legislation. And in the absence of some existing legislation that Congress has enacted, the FTC may not have the authority to issue any rule that would ban non-compete agreements. So it'll be interesting to see how this all plays out, because I suspect that there's going to be litigation if and when the federal government acts. But for now, to answer those questions that many of you might have in the audience, no, the president has not invalidated your non-compete agreements. They are still valid and enforceable for now, albeit under state law.
Thank you. Can an employer just include a choice of law provision in the agreement so that they don't have to have multiple agreements for each state?
Right. I've got some clients who thought, okay, I hear you. I can't have a one-size-fits-all agreement. So what I'll do is I'll just designate a particular state's law is going to apply. And that way I can use the same form across the country or in whatever states I have a presence in. Unfortunately, that isn't going to get you anywhere either in certain states, because, again, it's going to probably more likely depend on the law where the employee lives and resides. And in some states, for example, Louisiana, the non-compete statute expressly prohibits forum selection clauses and choice of law provisions in employment agreements. So, for example, if you're living and working in Louisiana, but you sign a contract that says Delaware law is going to apply to the enforceability of the agreement, if litigation is filed in Louisiana, no judge is going to enforce the Delaware choice of law provision. They're going to strike it as being invalid and against Louisiana public policy, and they're going to go ahead and apply Louisiana law to that dispute.
Craig, what about when an employer wants to enforce a non-compete agreement? Do they have the choice of where they can file the lawsuit, and does the location make a difference?
I definitely think, Lauren, that the location's an important consideration in the strategy of enforcing a non-compete agreement. There's some built-in constraints in the law that the employer needs to establish personal jurisdiction against the employee. The employer needs to generally file suit in a proper venue that has the right connections with the parties and their dealings. But the employer can sometimes gain some control over where the litigation is going to go forward by including a forum selection clause in the non-compete agreement or the employment agreement that basically chooses the location for the lawsuit. Courts, it's going to vary jurisdiction to jurisdiction, but courts often will enforce forum selection clauses if they're reasonable under the circumstances, meaning that there's sufficient connections to the employee and they're not having to go across the country, for example, to litigate a case. One thing I would like to bring up is, besides the sort of X factor of the forum being important, is the X factor of the judge. And that's a big factor in how these things play out. And what I mean by that is employers are often running to the courthouse trying to get injunctions to prevent their employees from doing X, Y, and Z and competing against them. And a judge, not a jury, decides an injunction. So there's a lot of power and a lot of discretion that one judge has in deciding whether to grant an injunction. And two different judges can hear the same set of facts, and one might decide one way and the other another way. So that's a big consideration, who's going to be deciding the injunction. And, again, that's specific. It depends on the circumstances. But in general, what we often see is that state court judges tend to be a little more employee sympathetic or lenient, more hesitant to enforce a non-compete agreement. And federal judges who, unlike state court judges who are elected, federal court judges are appointed for life generally. And in general, we often find that federal judges are more apt to apply the letter of the law in enforcing a non-compete agreement when the law requires that.
So it sounds to me, based on that answer, Fred, that there is some politics involved in the decision. Is there any way to get around that?
Well, if we have a well-written non-compete agreement and we think that we got a better shot of a federal court judge enforcing that non-compete agreement than a state court judge, then we're looking at ways to get into federal court under the law. And that can be challenging because, like Greg said earlier, non-compete agreements are basically governed under state law, at least currently. And so the question is, how do we get into federal court to enforce a non-compete governed by state law? And there's a couple of ways that we look for. One is if there's diversity of citizenship between the parties. And what that means is that if the employer is incorporated in a different state than where the employee lives, and the employer's principal place of business is also in a different state than where the employee lives, that's the first part of establishing diversity. And then the second part is that the amount of controversy needs to be at least $75,000. And in these kinds of cases, what that usually means is that the employee's diverted at least that amount in business. And so if we have those two parts of the test met, we have diversity to bring suit in a federal court. The other way that sometimes employers can file in federal court if they want to is if there's also been misappropriation of trade secrets. And as of 2016, there's a federal act governing that called the Defend Trade Secrets Act or the DTSA that we'll talk a bit about later. But those are a couple of the ways that employers can file in federal court if appropriate.
Okay, thank you. And Greg, you touched on this earlier. Can you describe some of the differences in the laws that govern restrictive covenants across states?
Sure. You know, I have some clients that have a national presence and sometimes want to send cease and desist letters and try to enforce non-compete agreements. And the first thing I always do is I look up where the employee is working and living for the company, because again, that's the law that I need to look to make sure that we're not overstepping or overreaching in whatever letter that we may send to the ex-employee. You know, in some states, non-compete agreements, which prohibit competition outright, are not allowed, period. For example, it's against the law in California, Oklahoma, and North Dakota. Non-compete agreements are not allowed. There's some limited circumstances in California where they are allowed, but that's generally in connection with the sale of a business. And then in other states, even though competition, non-compete agreements are invalid, there may still be a basis to implement non-solicitation provisions. You may recall when we started the presentation, Lauren went over all the various terminology that we're going to be talking about today. There's a distinction to be made between a non-compete agreement versus a customer or employee non-solicitation agreement. So even though it's not allowed in some states from a non-compete perspective, you may still be able to implement non-solicitation provisions. Still some other examples, go through some of them that are in our firm's regional footprint. In Louisiana, for example, you've got to list the parishes or municipalities where competition is prohibited. I see it all the time. Employers are trying to enforce non-compete agreements with what I call mile radius restrictions. The employee is prohibited from competing against the company within a 50 or 75 mile radius of where they worked for the company. That is not enforceable under Louisiana law. You have to list the parishes or municipalities where competition is prohibited. And in the case of an employee that might work in multiple states, for example, you may have an employee that works some in Beaumont, Texas, but they also service the Lake Charles area, or perhaps they work on the North Shore in St. Tammany Parish, but they also do some work for the company on the Mississippi Gulf Coast in the Gulfport area. In that situation, a lot of people say, well, wait a second. There's other states don't have parishes. What do we do there? Well, again, you can either list the municipalities, meaning the cities where competition is prohibited, or you could list the counties in those other states where competition is prohibited. So you have some options. And you can have your non-compete even reach beyond the state-specific jurisdictional boundaries of that state. Just make sure that you are taking a look at which state's law is going to apply and make sure that you're compliant. Some other nuances of Louisiana law would include a two-year maximum restriction on non-solicitation of customers and non-compete agreements. Some employers overreach and have them for much longer, 5 years. I've seen some as long as 10 years, which is going to be really hard to enforce. There's also, I'm going to talk, well, before I kick it off to Craig, I'm going to go over some of the other states in our footprint. For example, Georgia, before 2011, non-compete agreements were generally not going to be enforced in Georgia. Now they're routinely enforced post-2011 when the statute was enacted that authorized the use of non-compete agreements. Interestingly, what courts have done is not look at the time that the employee is terminated, but they are looking at the time the contract was signed. So if the contract was executed before 2011, you may want to revisit those agreements because they're probably not going to get you very far. If they were signed after 2011, your chances of successfully enforcing the agreements is going to be much stronger. In Florida, it may depend on whether or not the employee is an at-will employee versus an employee for a specified term. In the case of the latter, if the restrictive covenant is sought to be enforced against an employee that materially breached the employment contract and that was the result of their termination, you may have some problems enforcing that agreement. So it's important to keep that in mind. In Tennessee, the promise of continued employment has to have been substantially performed in order for you to enforce a restrictive covenant. And so, for example, if you hire an employee on January the 1st and you terminate them January 3rd, you probably are going to face an uphill battle enforcing that restrictive covenant in Tennessee because there has not been a substantial performance of the promise of future employment, which is typically the consideration that the employee is receiving in exchange for agreeing not to compete against the company upon being terminated. In Mississippi, it generally is going to depend on the circumstances surrounding the termination. If there are specific facts that may warrant not enforcing the agreement from an equitable perspective, that can sometimes factor into the analysis. By and large, though, Mississippi common law is pretty favorable to employers. So if you have a presence in Mississippi, your chances of successfully enforcing the non-compete are pretty good. I think I covered all of our other states except for Texas. Craig, I'll kick it over to you to talk about Texas.
Yeah, thanks, Greg. So Texas has a Covenants Not to Compete Act that is a set of 3 statutes governing whether covenants not to compete are enforceable in Texas. And in general, under the statute, the covenant not to compete needs to be ancillary to or part of an otherwise enforceable employment agreement. And it needs to be supported by the right kind of consideration. And what that means under the statute in the cases looking at the statute is that the employer needs to provide one of a few things, either confidential information to the employee. It doesn't necessarily have to be a trade secret. It can be a trade secret, or specialized training to the employee to support the non-compete. And under some more recent law, even stock options can support a non-compete agreement. And what we've seen over the past 10 to 15 years in Texas is that non-competes have become more easily enforced by the employer. The law has become a little less rigid and technical as far as when information needs to be exchanged and so forth. And nowadays, where we often see the disputes or the resulting litigation over non-compete agreements in Texas is whether on the issue of whether they're overbroad or unreasonable. And courts are looking at 3 things in that respect. They're looking at the time, the geographical area, and the scope of activities to be restrained. So every inquiry is fact-specific, and it's ultimately a reasonableness standard. As far as time goes, Greg mentioned Louisiana has a pretty certain 2-year max. Texas doesn't have that. It's a reasonableness test, but often 1 to 2 years is what we're seeing. As far as the geographic area, Texas doesn't require the counties to be listed like Louisiana does, but it needs to be reasonable and not too broad. So generally, that's going to be where the employee worked or had customers, that sort of thing. And then the scope of activity to be restrained is another kind of major area of dispute. And generally, that should be that the employee is restrained from doing the same or similar things that they did for the previous employer, but not every type of job or work in a particular industry. And so ultimately, the court's determining whether the non-compete's reasonable or overbroad. And if it is overbroad, there's a fix, but it comes with a penalty. And so if it's overbroad in Texas, the non-compete agreement can be reformed, which gives the court some latitude within certain constraints to rewrite the non-compete even a little bit, as opposed to like blue penciling and striking out language. The court has a little more discretion to make it only as broad as necessary to protect the employer's legitimate business interest. But the ding that comes with that is that the employer, under Texas law, cannot recover damages from the employee until an overbroad non-compete agreement is reformed. So it quite literally pays off for the employer not to be greedy and to keep their non-competes as narrow as necessary to protect their legitimate business interest.
Picking back onto what you just said, I just realized I forgot to mention something. You mentioned blue penciling and reforming the contract in order to make sure that it's able to be edited by the court. There's a severability requirement in some jurisdictions where your contract has to actually have a severability clause in order to enable the court to reform it. So that's another nuance that tends to get employers in trouble. For example, in Louisiana, if you don't have a severability clause in the contract, you're not going to be able to ask the judge to reform it. So just something to keep in mind. Sorry, I didn't mean to go off script. Lauren, I think you're up.
Okay. Greg, what are some of the legal consequences that an employer may face if they try to enforce restrictive covenants that are unenforceable?
Yeah, this is something that can really cause problems for employers. And you know, I alluded to this earlier. You want to make sure that you get it right and that you are not overreaching and that you're not asking the judge to enjoin or prevent the employee from working for a competitor when the contract that is underlying the request is unenforceable under the law that's going to apply to the dispute. By way of example, if you were to go into a court in Louisiana and obtain a temporary restraining order, more commonly referred to as a TRO, and the ex-employee is able to establish that it was wrongfully issued, the TRO, and they dissolve the TRO because you didn't have a valid contractual basis to enforce the non-compete agreement, you can be liable for attorney's fees and damages that have resulted from the wrongful issuance of the TRO. Another example in Louisiana is that if you knowingly seek to enforce an otherwise invalid agreement, that is a per se unfair trade practice and triggers the unfair trade practices statute, which, depending on the circumstances, could lead to an award of attorney's fees for the ex-employee, as well as treble damages under the statute. So it's just a minefield of things that you want to be, make sure that you get right and that you're not overstepping, because it can cause problems. In some other states, you might have an issue with being accused of tortious interference with a contract, meaning the contract between the ex-employee and their new employer, tortious interference with business relations, in terms of customer non-solicitation agreements. So there's all kinds of potential claims that can be asserted against you as the employer if you don't get it right and make sure that you're complying with the law of the state that is applicable.
Craig, what can an employer do if they have an unenforceable restrictive covenant and the former employee starts taking business?
Well, like everything, it depends on the particular set of facts, Lauren, but it's not uncommon for that situation to arise. It can arise for a variety of reasons. Sometimes it's overlooked, but sometimes the employer intentionally decides, I'm not going to be able to attract the talent that I want if I require a non-compete up front. Sometimes the employer doesn't vet their non-compete agreement and figures out after the fact that it's unenforceable, and for the reasons Greg said, the employer decides I'm not going to go there. So it's not uncommon to have a situation where there isn't an enforceable non-compete agreement for whatever reason, and the employer may still have a potential avenue if the employee's misappropriated trade secrets. There's a couple of bodies of law that govern this. One we talked about briefly earlier, and that's the Defend Trade Secrets Act of 2016 that prohibits the actual or threatened misappropriation of trade secrets. And that's a relatively new body of federal law that provides for a cause of action in federal court if the employer wants to go there. But the Defend Trade Secrets Act, or DTSA, does not preempt state law or replace it, is what that means. And so the state law governing the misappropriation of trade secrets still applies. And a number of states within our firm's footprint have adopted some version of the Uniform Trade Secrets Act, or the UTSA. I'll click off the list here, specifically within our footprint. Alabama, Florida, Georgia, Louisiana, Mississippi, South Carolina, Tennessee, and Texas have all adopted some version or form of the UTSA that provides for a state-based cause of action for the misappropriation of trade secrets. So there's a couple of bodies of law for employers to utilize if an employee's misappropriated trade secrets. But it can be challenging to prove that kind of claim as opposed to enforcing a contract with a non-compete agreement for a few reasons. First, the employer needs to prove that they do indeed have a trade secret worthy of protection. And generally what the legal requirements are is that first the employer needs to establish that they take reasonable steps to protect the alleged trade secret. That can be having a computer system with passwords. It can be having employment policies, various other ways that an employer can establish that they take reasonable steps to protect the information. Second, the employer must establish that the alleged trade secret has actual or potential independent economic value, that it's valuable. And third, the employer generally needs to show that the alleged trade secret isn't something that's easily publicly ascertainable or accessible. And so if the employer can get past that first hurdle and show that they do indeed have trade secrets worthy of protection, they still have to establish that there's been actual or threatened misappropriation of trade secrets under either federal law or state law. And so that can be challenging with a sneaky employee that's trying to avoid detection, right? One way that we see employers establish physical misappropriation of trade secrets is they bring in the computer experts to do a forensics analysis, or if they're big enough, they may have their IT department come in and do that work in-house. But still, it's often difficult to prove that employees stole confidential trade secret information from the employer. And so there's a doctrine that some courts have applied, not all courts, and it's only in certain circumstances, that has kind of eased the burden on the employer of proving physical misappropriation of trade secrets. And that doctrine is called the inevitable disclosure doctrine. And that doctrine, as the name suggests, basically is the idea that in certain situations, even without proving, physically stealing the information, that it's inevitable that the employee is going to end up using trade secrets in their next job. And there's typically when the doctrine's been applied, it's been in some circumstance where there's like an aggravating factor. And what I mean by that is it's been applied in situations where, say, the new employer is weak in a certain area of technology, so they hire employees from a company that's strong with that type of technology. That's one situation where we see it applied. Another situation where it's been applied is with research and technology type employees. And then probably the most common situation where I've seen it applied is when the employee's duties are extremely similar or pretty much exactly the same at the place they're leaving versus the place they're going to. And so those are some of the situations where the doctrine's been applied to make it a little easier on the employer on the proof of misappropriation of trade secrets. But I mentioned earlier the Defend Trade Secrets Act, which is still new and courts are still interpreting it, but it does speak a little bit to this doctrine. And the DTSA provides that an injunction may not prevent a person from entering into an employment relationship, and an injunction must be based on evidence of actual or threatened misappropriation of trade secrets and not merely on information that the person knows. Well, that sounds like it's limiting this doctrine, right? And so courts are still interpreting it, but a lot of courts are more hesitant to apply the doctrine, especially under the DTSA, because of this specific language within the statute. State statutes may vary a little bit and speak a little differently towards that issue or the case law interpreting it. Back to our firm's regional footprint and the states which have applied the doctrine. Texas, which tends to be employer-friendly, has not explicitly adopted the doctrine, but there are decisions where it's been applied in various situations. Georgia says no, it's not going to apply the inevitable disclosure doctrine, and there's still a lot of iffiness or undecided jurisdictions too, particularly Florida, Louisiana, Mississippi, South Carolina, Tennessee, and Alabama have not decided explicitly whether they're going to use the doctrine.
Thank you. Greg, so how can an employer avoid some of the legal pitfalls that we've discussed today?
Well, first and foremost, and I alluded to this earlier, I think you need to have your agreements audited. You need to make sure that you're not trying to have a one-size-fits-all agreement. You want to make sure that you are complying with the law of the state where the employee is working and or residing. And I think you should consider designating certain states. I've seen clients do it piecemeal. They'll say, all right, we're comfortable with having a form non-compete in certain jurisdictions because we don't do that much business there and we'll just take it as it comes. But we have a significant amount of revenue that's generated in Florida and maybe another state like South Carolina and Georgia, and they want to make sure that they get it right in those states. So they will engage legal counsel to have them draft an agreement that is state-specific. And while I recognize that that is not ideal from a human resources perspective, because you're going to have to make sure that you include the correct form in the onboarding documents with the employee, for all the reasons we've discussed here today, it really is worth your while to adopt forms that are state-specific. And one thing you're going to have to evaluate is whether or not, if you find out through engaging legal counsel that your agreements are not enforceable in certain jurisdictions, you're going to have to evaluate. I've had clients ask me, well, geez, what do we do about this? Do we have the employees sign now, or do we just let sleeping dogs lie and just do it on a prospective basis? That's probably going to depend on the employee at issue, how much access to confidential information they have. What may make sense for a small territorial manager may not, make the same sense for a national or regional manager who is very highly ranked in the company. You may want to require that the individual with the most contact with customers and the most knowledge of your trade secrets and strategies and customer pricing information, you may want to ask them to sign the agreement. So you're going to have to evaluate everything on a case-by-case basis, but generally speaking, the answer to your question, Lauren, is perform an audit. And if you need to fix stuff, get it fixed, and that way you won't have to worry about any of these issues going forward. I think we have time left for some questions. Let's see.
I see one. Can you define what severability clause and trouble damages are?
Yes, sorry about that. We sometimes talk in legalese and we forget that not everybody may understand the terminology. Treble damages means triple damages. So whatever the damages are that are established by the employee, multiply it by 3. So that can get really expensive very fast. What was the other one? Severability. Severability clause. Yeah, I'm sorry. Severability clause is a clause in the contract that says if any part of this is invalid or unenforceable, you, the court, are authorized to sever it from the agreement, meaning just take it out and it's like it never existed, and we're going to keep everything else in the contract that is enforceable in the contract so that we can enforce the provisions that are in fact legal and enforceable.
Another one is, what do you do if an employee refuses to sign the non-compete?
That's actually an issue I've faced before with some of my clients. It's a state-specific issue as well. In some states, an employee's refusal to sign a non-compete agreement after they've already been employed for a period of time is not grounds for termination. In other states, you can condition it on continued employment even if they've already been working for you. If the employee refuses to sign, you may want to try to enhance the incentive for them to sign, maybe a small bonus or some sort of signing incentive. There's a way to sort of skin that cat on a case-by-case basis. But in some states, if an employee refuses to sign a non-compete agreement, same holds true for arbitration agreements, you can terminate the employee if you want to. let's see, we're getting some more in. What did you mean by irreparable harm? Craig, you want to take that one?
Sure. Thanks, Greg. So generally, when an employer wants to enforce a non-compete agreement, courts require that the employer show likely irreparable harm. And what that means is that there's not just some hypothetical case that the employer could be damaged. You know, if the employee is working in X industry and goes to work in Y industry, even if that, you know, may violate the letter of the non-compete agreement, the employer is not showing that there's actual harm there. And so in enforcing the non-compete agreement and, you know, blue penciling it, reforming it, whatever the court needs to do, the court is generally going to require that there's some actual real likelihood of harm to the employer and not just theoretical possible harm. And so that's the requirement to get an injunction. One of the requirements is irreparable harm.
Okay. Well, I see that we're getting close to being out of time, and I don't want to keep people longer than we promised. We're respectful of everyone's time, and we appreciate you joining us here today. I just want to thank everyone for your participation, not just in this one, but in the entire Adams and Reese HR Summit. We started this last year due to COVID-19. We usually are on the road in person in various jurisdictions, but we decided to go virtual last year, and it actually turned out to be a really neat thing because it allowed us to cast a wider net and to include more people in the presentations that would otherwise not be able to attend, or physically attend, I should say, in person. So we're really excited about this. I think it's a platform that we're going to utilize going forward, and we would love to hear from you. I would love to hear feedback from you as the team leader as to whether you prefer the virtual platform, what you liked, what you didn't like. We want to improve it, we want to get better at it, and we want to make sure that you have a meaningful experience and that we're not taking too much out of your time or not giving you the content that you are looking for. So whether it's a topic or whether it's a scheduling issue, we want to hear from you. So please provide us with that feedback. And don't forget to sign your or get your certification so that you get your CLE credits. That's very important, and your HR credits. So on behalf of Craig and Lauren, I want to thank you for joining us here today. We appreciate having the opportunity to speak to you today.
Thank you.